Good morning and welcome to the DC Court of Appeals. As a general reminder, we ask that you mute your cell phones so as not to disturb this morning's arguments. Thank you. We'll be starting shortly. All rise. All persons having business before the Honorable Associate Judges now presiding over the District of Columbia Court of Appeals, draw near and give their attention. God save the United States and its on the court. This on the court is now in session. Please be seated and come forward.
Good morning and welcome to the District of Columbia Court of Appeals. We have two cases on our calendar this morning. The first case is 22 CV 975. Oh, sorry, excuse me, 22 CV 473. Monique Wilson versus the District of Columbia et al. Counsel, if you'll introduce yourself for the record and let us know how much time you'd like for rebuttal.
I'd like to reserve 5 minutes for rebuttal. Good morning. May it please.
And your name, counsel?
Yes, may it please the court. My name is David Branch and I represent the appellant Monique Wilson. The issue in this appeal is whether the trial court resolved factual disputes that should have been reserved for the jury. Ms. Wilson was employed as a grade 12 budget analyst with the DC Office of Chief Financial Officer. She was placed on a 90-day performance improvement plan on October 10th, 2018. 21 days into the 90-day performance improvement plan, she was terminated. She has claims under the DC Human Rights Act for race and gender, sex discrimination, retaliation, claims under the DC Accrued Safe and Sick Leave Act and the DC Family and Medical Leave Act. After she was placed on the performance improvement plan on October 10th, she took some sick leave during I believe it was a total of 5 days through October 30th. The district terminated Ms. Wilson in part, and this is acknowledged, because she took sick leave, because she was absent or she took sick leave during this period of time. Now, the district could terminate her for any reason. They just could not terminate her for discriminatory reasons, and they couldn't terminate her because she took sick leave. I think
counsel, is it undisputed that the termination, or if in your view, undisputed fact that the termination was due to taking sick leave or due to taking unscheduled sick leave / improperly notifying the appropriate individuals about sick leave and scheduling it and logging it?
So, Your Honor, I think in the joint appendix, the district, there's a recommendation for Ms. Wilson's termination. I think this is at maybe 255 in the joint appendix, where Ms. Cheatham issues a letter and she says words to the effect that we knew that we were going to have a problem with Ms. Wilson and that she would take leave. She would probably take leave. So it's our position, although the district claims that she was terminated in part because of unscheduled leave, and we're not disputing the fact that she took 2 days off, I think the 11th and the 12th, and she requested sick leave. And then there was another day where she had a doctor's appointment. So I
guess let me ask you a different way. Do you agree that it's undisputed that the sick leave, I realize you can't schedule it in advance in all cases if you're sick, but that it was not properly logged into the system, or the shared calendar with, protocols were not properly complied with, or emailing Mr. Blake, I think?
Yes, Blake is the supervisor.
Right. I mean, do you agree that that didn't happen the way it was supposed to?
I agree that it did not happen, but I don't think the statute makes a distinction between whether it's scheduled sick leave or unscheduled sick leave. My understanding is that Ms. Wilson requested, she was absent, she requested leave, and she said, I will be sick the following day, or I will be out the following day as well. But our position is that
I'm sorry, just to drill down, are you saying that you don't think following protocols vis-a-vis sick leave matters at all? So if I just don't show up to work for 3 months because I'm sick, but I don't tell anybody about it and I don't fill out the right paperwork and I don't advise my supervisors as I'm supposed to in the timely manner, but then subsequently I document it, you think that that's okay? That can't be a consideration in terminating me if I just didn't follow the protocol?
Your Honor, if you absolutely did not follow the protocol whatsoever, yes, that would probably be a valid consideration. But here, Ms. Wilson, she was absent and she said, she provided notice that I'm sick, I'm going to be out sick the next day. And she had been, experiencing mental health issues or issues that needed to be treated due to the anxiety, the stress, everything else that was happening. And this had been going on for a number of months before October 10th and October 11th, 2018. And the statute is clear that if employment action occurs within 90 days of this request for some type of leave, then that there's a presumption that there was a violation of the statute. That's under the Accrued Sick and Safe Leave Act.
Sure, there's a presumption, but what if the record reflects that the issue with sick leave is one of 10 different reasons to fire an employee, and the 9 other reasons are amply adequate to support the determination that the individual is just not qualified for the job, is not performing up to standards. Those are just 2, but give 6 other additional reasons that show that there is ample reason to terminate this employee. What then? Is there really truly a triable issue of fact?
Yes, Your Honor, that just makes it a mixed motive case where the issue goes to the jury and the jury has to decide, was it the termination because of her sick leave or because of these 8 or 9 other reasons? So, Your Honor, I think that's still an issue that needs to be tried and decided by the jury. If there are other reasons that the district is asserting that there are other reasons, the trial court just doesn't get to discard the reason asserted by the plaintiff and say, okay, well, there are all these other reasons and therefore you don't have a case, your claim is kicked out, it's dismissed.
Let me ask you to follow up on that, Mr. Branch. The sick leave is one of 5 separate counts that you put in your complaint. One could take the view that the record shows that your client richly deserved to be fired because of poor performance, and that she could have been terminated and was terminated without race or gender discrimination. And the only thing you got is the argument you chose to lead with, the sick leave. It would seem odd for us to allow a jury to send her back to work since she was such a poor performer. That is the presumption connected to sick leave so strong that it cannot be overcome by the proof of poor performance that justified firing her?
So, Your Honor, I will respond by saying that this addresses in part Judge Easterly's question. Sending her back to work is not the only option that would be available to the trial court. There could be a finding that there was a violation of the Accrued Sick and Safe Leave Act, and we would add on to that DC Family and Medical Leave Act, because if she had a medical condition that warranted, that would be approved under the DC Family and Medical Leave Act, the same options would apply. You can't retaliate against someone because they take FMLA leave for this Accrued Sick and Safe Leave Act. But there could be a finding by the trial court or by the jury that there was a violation of the law. And that has value. There's nothing that requires that would require that she be reinstated to work if it proceeded as a mixed motive type case.
But you don't want just a declaration. You want money, right?
Well, Your Honor, the declaration has value as well, that the District of Columbia Office of Chief Financial Officer violated the District of Columbia Accrued Safe and Sick Leave Act by retaliating against this employee, which it seems to in some fashion acknowledge that this action was taken in part because she took leave. So that's Your Honor, so that's the argument on the Accrued Sick and Safe Leave Act and the DC FMLA claim. There's also an issue with how the court resolved the hostile work environment claim. The court essentially said that, just stated that there's a hostile work environment claim, but says that she did not meet the standard for a disparate treatment, where there's a different standard for a hostile work environment. And The court does not really address what she alleges was a hostile work environment. And we believe that that's an issue as well.
So clarify that for me. Is it enough to establish there was a hostile environment without linking that to race or sex? Or didn't the court also say you haven't linked it to race or sex?
Yes, it does need to be linked to some protected class, but she did report to Mr. Bolden that she believed that Mr. Bolden was another supervisor. She believed that Mr. Blake was taking these actions against her because she was a woman. And what she described from Mr. Blake was the constant berating, dismissiveness, looking at her with a look of disgust or a lame look.
Perhaps that is at best a conclusory assertion. When she was pressed in discovery to identify instances where men or white people were treated differently, she couldn't provide any detail.
That's correct, Your Honor, but she asserts that that she was singled out for what she perceived to be a hostile work environment, and she thought that it was based on her sex or gender. And Your Honor, I'd like to reserve the remaining minutes for rebuttal.
All right, thank you, counsel.
Good morning. May it please the court. Holly Johnson for the District of Columbia defendants. I'd like to start with the Sick Leave Act because that seems to be where the focus is today. As a top level point, Ms. Wilson's failure to dispute the performance-based reasons for her termination is independently fatal to her Sick Leave Act claim. She raises on argument for the first time a novel notion that there's some sort of mixed motive analysis that's available under the Sick Leave Act. This is forfeited. It is far too late at argument to suddenly be challenging the but-for causation standard that has been asserted by the district so far in this litigation under this analysis. This is a new statute. This court has never ruled on it, has never had a case under it. And before this court starts to get into what sorts of analysis is available, it should be fully briefed by the parties and raised. But beyond that, and I'd be happy to talk about why mixed motive analysis isn't appropriate, but I don't think we need to get there because there isn't even an inference here that the fact that Ms. Wilson took sick leave was a factor in her termination. So I want to start by clarifying the record.
Well, let's clarify the record.
Of course.
You said there's not even an inference here,
No.
but I've read and reread the certain pages from the deposition of Miss Rice. And she clearly says her taking sick leave right after her failure to show up, taking sick leave right after being given the PIP was a factor in my decision to terminate her.
So I think that if you read the deposition, that section starting at it's on page, it's JA 171, but it's page 69. It's a manuscript, so there's 4 pages. It's page 69 of the deposition. If you start there and you go through the next page down to 70, you can see that although Rice at one time said the word sick leave, but that wasn't the reason there was a problem. And I will contend that on this record, there's no evidence that at the time that the decision to terminate was made, that decision was made within 2 days of the PIP decision, that Rice even knew that it was sick leave that Wilson was taking. Because what Wilson did was she sent an email at 10:30 a.m. So after the workday had started on October 11th, and her email said, "I will be out of the office today and tomorrow." Period. She didn't say she needed sick leave. She didn't say she was sick. She didn't give any explanation, and it didn't even follow the requirements of being before the shift started. Beyond that, she has not even asserted yet, much less provided evidence that this wasn't for doctor's appointments. That's really what her brief and her testimony say, and that's scheduled leave. That needs to be 10 days in advance of notice. So she hasn't satisfied her requirements under that. So, and what I want to, and now I'm happy to walk through those pages of the deposition because what she said, the question was, did anything happen between October 10th, when she was issued the written warning and the PIP, and October 11th or 12th, when you decided she should be terminated? And Rice says, yes, I believe she showed no intent to improve her performance. And then she says she called out sick the next day. And then, like 2 questions later, Rice clarifies, but I didn't believe we should have issued the 90-day PIP in the first place. And then when they start going through more of this testimony, so the question is asked again, is it true that one of the reasons you recommended her termination was because she called out sick? Then the answer is she used unscheduled leave, and she also didn't show up for work, which is the most egregious. She was AWOL one of those days she claims is a sick leave day. And then she says, the question again is, well, is it true that one of the reasons you decided to terminate her was because she took unscheduled leave after she was issued this performance improvement plan? And then Rice says it was a factor. It was the unscheduled leave.
If you are truly sick, you can't schedule that in advance.
Of course.
You wake up one morning and something's wrong, but you just can't get out of bed. You can't schedule that in advance.
Of course, but Ms. Wilson doesn't claim that that's what happened. She doesn't allege that that's what happened. She does not even allege, she doesn't even allege that she was sick on that day. In sworn testimony, there are allegations in her brief, but there's no sworn testimony about that. And beyond that, she didn't say in advance of her shift that she was sick, and she didn't give the reason. I think this is the most important of these factors. In her email saying she was going to be out, she doesn't say she's taking sick leave. She just says, I'm going to be out today and tomorrow after the shift has started.
But I mean, does someone have to actually be sick? I mean, obviously, as employers, we don't want this, but if someone has sick leave, doesn't the act allow them to take it? And I mean, if they're sick, if they're a little sick, if they're really sick, they got hit by a bus, I mean, anything in between there, are courts really, or juries really supposed to be looking at? I mean, is there any requirement that they submit medical records or doctor's notes or anything like that?
No, not for taking, unless you take 3 consecutive days. At that point, you have to have some sort of documentation. But no, and of course, especially with this level of employment, this is mostly a system of trust. And this is one of the things that I wanted to explain to this court. The district's timekeeping system has the employees enter their own time into the timekeeping system. There are 2-week pay periods, and about 3/4 of the way in, like the Wednesday before your pay period ends, that's when you enter the reasons for all of your leave. This is why I say a jury would have to speculate to find that Rice even knew at the time that she made the termination decision that it was sick leave that Wilson was taking. I do suspect that the statute requires you to be sick, but how sick, who knows? You can't take a sick day and then go on vacation. You can't, I do think there's something about that, but the district is not contending that Wilson was not sick. We're not contending that. What we're saying is that she didn't tell anyone she was sick, and she didn't follow the proper protocols. And then of course, what we're saying beyond that is that that's not the reason for her termination. I would advise this court to take a look, if it's helpful, at page 28 of the district's brief, where we have a bulleted list of the performance-based reasons for her termination. Any one of those reasons would be legitimate, justifiable grounds for discipline. For some of them, termination. She does not dispute a single one of those. Her entire case rests on her claim that Rice was basing the termination on what Blake told Rice. But she doesn't dispute the truth of anything.
But
that
I mean,
Blake told Rice.
would you agree that, let's say there are 10 independent performance-based reasons for termination, but the record reflects, and I'm not saying that it does or that you agree that it does, but the record reflects that a supervisor very clearly erroneously mentioned use of sick leave, and forget unscheduled use of sick leave, that even if termination could be upheld or rejected by a jury, that there could still be an independent violation of the Sick Leave Act, the remedy for which, I don't know, put aside for a moment, but that there still could be a separate freestanding violation of the Sick Leave Act, even if termination was otherwise appropriate?
So I think that would be an improper reading of the statute. And again, I'm going to get into it, but I want to say this is not something that's briefed, because it is not something that Wilson has raised. It's not something she's argued. That said, I think it would be a gross misinterpretation of the statute to hold that some sort of mixed mode of analysis can apply under the Sick Leave Act. The Sick Leave Act was enacted right around the same time as the DCWPA, and it was enacted the year after, the amendments to the DCWPA. Leave that aside. So in 2007, this court interpreted the WPA to require but-for causation. And in 2000, and the statute at the time and still says that the reason that causation has to be because of and that's why it's but-for causation. So that's in 2007. The next year, the council enacts the Sick Leave Act, uses because as the same standard, and was operating presumably with this court's decision in its background. Because of means but for. Also, I will note that the Sick Leave Act is kind of an extension of the FMLA. And this court has held that under the DC FMLA, an employee is not entitled to any relief if they would have been terminated otherwise. That's in Washington Convention Center versus Johnson on 953 Atlantic 2nd, 1064, 1077 is the pinpoint, and that was in 2008. So the cases that are the closest analog to this require it to be but for causation. I would also say that if this court were to find that an employee could fail to show up to work, call it sick leave, and create a mixed motive, that would incentivize employees who know they're going to be fired. And there's evidence in the record that Wilson was very concerned when she was put on the PIP that she could see the writing on the wall. She thought she was going to be fired, to start abusing sick leave so their supervisor would put it in the termination memo and suddenly they would have a claim.
What you've just said makes good logic, but it seems to me maybe there's some factual inquiry mixed into that. Does one have to find facts in order to determine that she's falsely claiming sick leave in order to insulate herself from being fired?
No, I don't think that you would have to find that she's falsely claiming sick leave, but I think an employee could create a situation where the employer puts it in a termination memo, for example, requesting termination by not saying that she's taking sick leave, later classifying it as sick leave. Again, we are not contending that Ms. Wilson was not sick. She didn't tell anyone, and she says so in her deposition. She says that she had health problems that she was hiding, that she didn't tell anyone about them. I mean, if you look at her FMLA claim, and I did want to address this, she didn't even request the FMLA forms until after the request for her termination had been sent to Human Resources. So there's no way she could have a claim there either. And the bottom line is this. I have never seen a record of an employee's performance so thoroughly and consistently documented from the moment they started employment to the moment of their termination. And if summary judgment isn't warranted here, when she's offered no evidence of nefarious inference, when she did not even properly use the Sick Leave Act, and when it is undisputed that she was incapable of performing the basic functions of her job, I can't see a case where summary judgment would be warranted.
Can we talk about hostile work environment for a
Yes.
minute? It seems to me the best argument you have going here is that Mr. Blake was an equal opportunity abuser. He was nasty to everyone, so there's no proof that he was nasty to her because of her gender.
I mean, I think that's the easiest way for the court to rule on. It's the approach that the Superior Court took. I don't think there's evidence that he created a hostile work environment for her. He criticized her performance. His critique was justified. Ms. Wilson's claims about his hostile and abusive tone, she says, look at his emails. They are hostile and abusive. Well, his emails are in the record and they are not objectively hostile and abusive. They are blunt assessments of her performance, which she does not dispute were true. So if she thinks that that was hostile and abusive, she certainly has given us no language that he used that was hostile and abusive. So I don't think she's satisfied the first step. But there's no reason for this court to rule on whether a hostile work environment existed because she's offered no evidence that it was based on her sex. And in fact, her attorney concedes that that is necessary here. But
he says it existed, that she told Mr. Bolden that Blake was picking on her because of her sex.
Well, she said that after her first encounter with Blake, she told Mr. Bolden that she thought Blake didn't like her because of her sex. So let's be clear about what she said. But also, who cares what she said? That's not evidence of a hostile work environment. Any employee can say, I think it's because of my sex. That doesn't mean that it was. In fact, employees are required to produce some inference of discrimination beyond their own opinion that it was based on sex. So even if she had actually testified, and she didn't testify, to be clear, that she, at the time of deposition, thought it was based on sex. But even if she had, what she thinks it's based on doesn't matter. The court has to have evidence that it was based on sex. And so even if this court were to disregard the evidence that Blake treated male employees poorly, which is again, just Ms. Wilson's testimony about what they told her, but that just serves to bolster the claim that he was treating everyone the same way.
Is it absolutely true that what she says doesn't matter, or is it more that what she says can't be wholly conclusory, right? I mean, if she had given sort of a detailed accounting of whenever we walked into a conference room, he always asked me to get the coffee. He never asked anyone else to get the coffee. He, would drop things on the floor and ask me to pick them up. He never asked anyone else to, right? If she had given some detail from which one could infer sexual discrimination, gender discrimination, wouldn't that be enough? Is it just that her just saying, I think it's because of my gender or sex, without any supporting information is the problem? Or how far does your argument go?
Well, I think what you've described are sort of two different ways that you could raise an inference of discrimination. I think there are certain words and actions that could infer sex discrimination, even if if there's no evidence about how anyone else was treated.
I'm just pushing back on your statement that you're saying sort of what she says doesn't matter. There has to be evidence. And couldn't the evidence come from her testimony?
Absolutely, it could come from her testimony. Okay. Sure, if she testified that there were certain words that he said that we know are sexually charged, then of course that would work. If she testified about specific actions that are sexually charged. And frankly, what she said to Bolden isn't testimony, but if she testified that she personally felt like it was because she was a female, well, that would be her subjective belief, and that is important to the analysis. But she has to show objective evidence. So it's really a failure of evidence here. A sexual harassment claim can be based entirely on one witness's testimony, including the plaintiff. I'm not suggesting that she's not to be believed. I'm suggesting she did not put the evidence in the record. I apologize to go backwards, but there's one more thing I wanted to point out about the sick leave claim, just to clarify, because Mr. Branch just said that she took 5 days of sick leave right after she was placed on the PIP, and that's not what the record reflects. 2 of those days were in PeopleSoft, marked as personal leave, not sick leave. And if you look at page 359 of her of the joint appendix, in her sworn answers to interrogatories, she identifies October 11th as also a day that she took personal leave. So maybe she doesn't even remember that she entered that as sick leave in the system. So I just want to clarify that she was gone for 5 out of the first 10 working days of her PIP. And the evidence is only clear that 2 of those she even later marked as sick leave. And so I just wanted to clarify that part for the record. So with regard to hostile work environment, the Superior Court didn't reach the question about whether the work environment was hostile. This court need not do so as well. She plainly has shown no suggestion that Blake's management style, to the extent it was hostile, was based at all on race or sex. And so summary judgment would be warranted on that as well.
Thank you, counsel.
Thank you.
First, Your Honors, in terms of the number of days that she took on leave, the Accrued Sick and Safe Leave Act protects sick leave or whatever type of leave that she took during this period of time. So it doesn't really matter if it was sick leave or it was just regular accrued leave. Now, unlike some cases where an employer goes directly to termination, in this case, we know that the termination was based in part, at least the early termination was based in part on her taking sick leave, whether it was sick or accrued, because she was on a 90-day performance improvement plan. All the district had to do, if they were concerned about her performance during this period of time, is allow her to continue to work for the 90 days and then terminate her. The only explanation for terminating her before the PIP ended was because she had taken leave. Agency.
I thought there was
district council.
evidence in the record that the person who fired her asked counsel, said, I don't think she should have been put on a PIP to begin with. Can I fire her now? And she was given legal advice that she could. So that evidence is in the record, no?
Yeah, that is in the record, but we also have the recommendation for her for the termination. I think that's dated October 22nd. One of the issues with Ms. Rice's statement or declaration in the record is that she does not attach any dates to when she made these decisions about she was going to terminate her in any event. It doesn't seem likely that she made that decision before October 22nd because we have this memo recommending the termination at that time. So,
I mean, counsel, there were other, aside from the sick leave, there were other performance errors that occurred early in the PIP period. Is that right? Or is
I think that there may have been one or two issues during this PIP period of time, but of course she was on sick or on some type of leave for, I think, 5 of the 10 days during this period before there was a recommendation that she be terminated. So there was really, I don't think that there was anything that could have been done anything substantial that could have been done during this period that would warrant her immediate termination when she was already on a performance improvement plan with detailed goals and statements and requirements for this PIP period of time.
I mean, are you saying there's a legally cognizable right to not be fired until the conclusion of a PIP period?
No, I'm not saying that. If there's a clear reason for terminating someone before the PIP ends, but if there's a dispute as to whether the early termination occurred because of someone taking leave and for some other reason, that's an issue that has to be resolved by a jury. A judge can't decide, well, it wasn't because of the person taking leave, it was because of these, 1 or 2 performance issues that we saw during the period. That's a classic disputed fact that needs to be resolved by a fact finder.
Don't we have to look at what a reasonable fact finder would have considered? I mean, if the evidence is this individual is not qualified to do the job, is unable to do the job, and has made serious errors while on the job, and also she took sick leave without documenting it for 2 days.
Your Honor.
I mean,
I understand that, but if the supervisor decides that there's something redeemable in this person.
Over a year and a half,
yeah,
she
but
has demonstrated that she is not qualified, unable to do the job, and has made serious errors that reflect adversely on the agency. And then there's the 2 days of undocumented sick leave. That goes to a jury?
Your Honor, if the supervisor decides that there is something redeemable that warrants placing this person on a 90-day performance improvement plan and giving her certain objectives to meet over this period of time.
But we're talking about Ms. Rice. Ms. Rice determined, looking at the whole record, there was no reason to put her on a PIP, right? Looking at the whole tapestry of her employment at the agency, said this person shouldn't be on a PIP. We just need to fire her.
Your Honor, I think the action taken by Mr. Blake has to be imputed to Ms. Rice, to senior people at the agency.
I saw that in your brief, but why, you raised cat's paw in your reply brief for the first time, as far as I can tell. So why would we impute that? I mean, first of all, it's not clear to me that argument is not forfeited, but even if it were, what evidence supports that theory?
Mr. Blake is acting on behalf of the agency and taking this employment action against Ms. Wilson. He's not operating independently. He's not making this decision that, hey, I'm placing her on a PIP.
He did make it independently, because if he had conferred with Ms. Rice would have said no.
Well, I think that's something that needs to, that testimony would have to be, subjected to some type of cross-examination. before before the jury and not, we can't just rely independently. A supervisor can always say, okay, well, I didn't know anything about it. But if you look at all the other factors, what is the normal process of when someone would be placed on the PIP? Would it go through human resources? Would it come to you? I mean, if those types of considerations need to be submitted.
Isn't that the kind of evidence that you should have developed below to question Ms. Rice's assertion of he never should have been, or she never should have been put on a PIP? I'm not following you as far as, the need.
What I'm saying is that Mr. Blake was speaking on behalf of the agency when he placed Ms. Wilson on this performance improvement plan. And I think there's evidence that he actually talked to Ms. Rice about Ms. Wilson. And then we have Ms. Cheatham talking to Ms. Rice and Ms. Cheatham talking to Ms. Wilson. So it's hard to fathom that Ms. Rice was somehow not aware that Ms. Wilson was raising the issues that she raised before the decision to terminate her was made.
All right.
Thank you. No additional.
Thank you, counsel. We appreciate your argument today, and this case will be submitted. The next case on our calendar today is 22 CF 960. Travanion Ward Minor versus the United States. Give you all a moment to get settled. And when you're ready, counsel, if you could introduce yourself for the record and let us know how much time you'd like for rebuttal.
I'm Richard Goldberg for Mr. Ward Minor. Reserve 4 minutes for rebuttal. May it please the court. The question before this court is whether, in a traffic stop, when a police officer issues a series of orders repeatedly accusing a person of wrongdoing, exercising complete control over the person stopped, including handcuffing him, and concludes with the statement, "Going to check you," can that statement of fact be converted into a request for consent by adding, "That's cool," and waiting a second? I think that the handcuffing here is the inflection point. In the period leading up to the handcuffing, every order required compliance. Any deviation was cause for suspicion. Show me your hands. Don't move. Don't move. Then move. Don't move. Don't move. Move. And where he questioned an order, he was quickly corrected. The question was converted into a reason for further suspicion. And that police questioning convinced Mr. Ward Minor that he could not refuse. That was coercive, not voluntary.
So counsel, you're starting with voluntariness, and the government argues in its brief that you are not challenging the actual provision of consent here as a separate piece from voluntariness. Is that right?
That's not accurate. I don't think he gave consent, but the point is whether the consent was voluntary. There's nothing in the record. You have the video where he says he consented. There's a strange nodding of a head shown by hair, but there's nothing in the record that says he actually spoke any words of consent. And when the police officer was questioned about whether Mr. Ward Minor, in his view, affirmed his the search, he said he actually wasn't sure whether Mr. Ward Minor was saying, "Yes, you can search me," or "Yes, you're going to search me. I recognize that."
Oh, okay, I'm sorry. I'm a little confused by your answer, but is it your argument that he did not, in fact, provide consent? And if he did, it wasn't voluntary?
Yes.
Or, okay.
Yes, that under these circumstances, any consent could not have been voluntary. And also he didn't give consent. And I think that where we are is a little different than where we've been. Body worn cameras are changing everything. For a long time, you usually only had the testimony of police. Where a defendant testified, the trial court would decline to credit the testimony. That's not a statement of the world, it's just how it got here. Where an officer might say, "I asked him if I could search him," and the defendant might say, "He told me he was going to search me." Both could be telling the truth. Those could be things that could be credited from their own points of view. The officer believes he's made a request. The defendant never saw it as a request at all. But here, the standard is subjective. What was the defendant's point of view in light of all of his characteristics? And here, it was incredibly coercive. It's not just that he was handcuffed. The government points to a couple of cases about where different courts have said, including Supreme Court, that handcuffing isn't enough. But one of those cases is Watson. And in Watson, the guy was given Miranda warnings, or the woman, I think. In Lee, which is a Sixth Circuit case, all that happened was police had handcuffed the guy and patted him down and then said, "Is there anything in this apartment that you should not have?" And he said, "No, go ahead and look." Those are not like this case. In this case, it was the repeated orders. Mr. Ward Minor was always under police control.
So, counsel, let me take you back a little bit, back to the consent question, but you brought up the body worn camera footage. So, I mean, would you agree that the question of whether consent was provided or not is reviewed for clear error? That's a factual question.
So I do agree with that, but not all credibility findings are equal. And the learned judge who said that was comparing testimony to physical evidence. In that case, it was telephone records, but here it's body worn camera footage. And you are perfectly able to look at the video as the trial court was. And I think it's important that the trial court did not make any findings where it made credibility findings, did not make any findings based on the impression it was given by the witness testifying live.
I guess I'm a little tripped up as to why you think the consent issue is a question of credibility. I mean, we've got the officer's testimony, but we've also got the body worn camera. And so, it's just sort of a factual question of what happened. There's the nod, right? You can't see the nod. You can just see his hair moving up and down, right? On his chest. That seems to suggest that he's nodding his head. But the nod comes before, as I viewed the video, before the officer says, "I'm just going to check real quick, okay." So that would be sort of an odd thing to rely on as far as consent, factually, right? Set aside credibility. And then there's what the officer actually said, which we can hear on the tape. And I think that the court didn't quite capture the exact words of what the officer said. And so we just have to assess whether or not those words and what, if anything, was said after those words were consent before we even get to the voluntariness question, right? Am I thinking about this correctly?
I think that's right. I would only add that it's exactly right. You can look at the video. The reason I mentioned credibility is that because there's nothing in the video that shows, I think, that he said yes or affirmative. The officer says there was an affirmative answer. That isn't in the video. And so to the extent that that's a credibility finding, when the court says that he either affirmed or said yes, which is definitely not video, I think that can be compared against the video itself. So there are a couple of points that I think we should focus on. All these orders did not come in a vacuum. As you can see from the video, and there are some pictures that are just screenshots from the video in the brief, this is a secluded area next to a vacant lot. There were cars speeding by, but there were no pedestrians anywhere to be seen. And a number of cases point out in whether this is in what makes something less voluntary, that there are no pedestrians around. There were at least 3 armed police officers and 2 police cars. And as the trial court found, Mr. Ward Minor was understandably nervous during the encounter. I think that there are overlapping factors in both this court's voluntary consent cases and the seizure cases that deserve some looking into. I think this case is very similar to Bumper. In Bumper, police showed up and claimed they had a warrant. And the testimony from the grandmother who was in the house was remarkably positive. Go ahead, I would have let you search no matter what you wanted. And the court said, when you have a claim of authority, an assertion of authority, then what happens next is not voluntary. And I think that's what happened here. The police exercised overwhelming authority over Mr. Ward Minor. Anything he did, any slight deviation was stopped immediately. By the time that had concluded, his handcuffing behind his back, his arms pushed up. I just could not have been voluntary. And I'd contrast this case with Henderson. In Henderson, the defendant was Nazis, it was considered to be voluntary. Freedom of movement wasn't curtailed. He was not badgered. There was no subtle interrogation. I don't know how subtle the interrogation was here, but it wasn't even subtle in that case. And this, I think, case is quite different. If you don't have any more questions on that particular issue, I will move on to the protection issue. I think that a couple of days ago, this court heard a case about a voluntary, whether a plea was voluntary.
Mr. Goldberg, I'll confess my frailties. I'm having a hard time hearing you, and that's in large part my fault, but you also speak very quickly.
I do.
So could you raise the volume and slow it down?
Absolutely. I can do both those things. On the question of equal protection, I think that it was really unclear what was happening during the plea colloquy. You have a written agreement that essentially strikes out that appellate rights are waived. And I think that's very important because for a plea to be knowing, intelligent, and voluntary, the defendant has to know what he's pleading to and know what he is waived. Excuse me, for a plea waiver.
I was intrigued by this argument, but I first recognized it in your reply brief. Is that too late? You seem to essentially saying he didn't give up any appellate rights at all.
So we argued the issue, and then the government in its brief said, oh, no, you waived it. And so we argued, no, we didn't. I don't think that's too late. And I think that the details that the government brought forward are very important. It's clear that he believes he's only waiving his appellate rights. There's a long colloquy where the trial court essentially just asks him, do you understand you're waiving your trial rights? There's a section that says waiver of appellate rights that is crossed out in the written plea agreement. At one point, the judge says something about suppression motion. But by that time, it isn't clear that the defendant has been advised even by his counsel that he might be waiving anything other than his trial rights.
Let me present an alternative view of the record and ask for your reaction to that.
Okay.
I think one might read this record to say that everybody in the courtroom understood that what defense counsel was preserving were the rulings that had just been made at that hearing, denying the motion to dismiss on equal protection grounds and denying the motion to suppress. If that's a fair reading of the record, then how can the denial of the motion to compel some 2 years earlier be properly before us?
So if that were a fair reading of the record, Your Honor, then I think if everybody thought that he was only reserving his rights to the decision that was made in the room, then I think you're right. But I don't think that's what the record shows. I think that everybody there thought he was reserving his appellate rights. There was some confusion with the trial judge who wasn't totally sure about the conditional plea and how it was going to work. But the judge himself did the paperwork and he set it up where he said, at one point he said,
as I understand the case law, there never was such a thing as a conditional plea to preserve some appellate rights until Rule 11 came along and specified the terms for preserving certain appellate issues. You seem to be saying that irrespective of the requirements of Rule 11, with conditional pleas, one can preserve appellate rights across the board?
I think that's right based on this court's cases. And the reason is that Rule 11 pleas aren't always perfect. And so this court has had to develop a system for what happens when they're imperfect. In this case, it was far from perfect. And I think that's the issue here, is that the defendant could not have understood that he was waiving some appellate rights and not others, when he was told repeatedly that he was not waiving any appellate rights.
But I mean, but the court, you acknowledged this earlier, but the court said as to suppression, right? And trial counsel said yes. I mean, I'm not, and we have this case Casey that seems to govern here. I don't understand how it could have been more clear that he was preserving some appellate rights and not others.
At one point, the judge says something about, the judge says something about preserving suppression, but the rest of the time they talked about just preserving his appellate rights. And only waiving his trial rights. And I think that is very important, because I don't think that the defendant can have a knowing, intelligent, voluntary waiver of his appellate rights, thinking that he was preserving his appellate rights and only waiving his trial rights.
So is your argument that there's a gap, that suppression, the ability to appeal the suppression ruling was clearly discussed? The ability to appeal the motion to compel was not discussed at all. And the waiver of his trial rights was discussed. And so on that backdrop, you can't impute a waiver to him on the second?
I think that's right, except that I don't think that suppression was discussed clearly. It was mentioned, but most of the time was spent saying you're waiving your trial rights, you're preserving your appellate rights. And there is a gap.
Well, I mean, the court says you will maintain your right to appeal the findings of the court with regard to suppression. So after your sentence, you can appeal the findings of the suppression hearing. If the Court of Appeals determines I got it wrong, they'll send it back to me. Do you understand? Right? That's on A220.
Right, and that's affirmative.
But then at the end, right before they finish up, the court says, well, I find you made a knowing and voluntary waiver of your rights to trial. And doesn't say anything else.
I think that's right.
That's on 226.
Yeah, I think that's right. I think that, by the way, the government didn't mention anything either, as the judge repeatedly said, you're preserving your appellate rights, you're only waiving your trial rights.
But the default is that a guilty plea waives appellate rights, right? I mean, that's the baseline. So the
Yes.
whole point of a conditional plea in Rule 11 is that any carve out would necessarily have to be affirmative. And so if the only affirmative carve out here was for suppression, then what am I missing?
I don't think that's the only affirmative carve out. I think that throughout the colloquy, and the judge tells him you're preserving your appellate rights. And the distinction, when he says, here's a thing you're preserving, does not tell the defendant you're not preserving anything else.
Mr. Goldberg, let's assume that the denial of the motion to compel is properly before us. What relief are you asking from us?
A new trial where after the government is required to produce this information, that would permit the lawyer to have an expert to provide statistical information. The near data is unbelievably specific.
I need some help with that. So far as I've discerned, you haven't demonstrated to us that there was error denying the motion to compel. And what standard governs the decision to grant discovery? Are you relying only on Rule 16 and Brady, or what case law are you relying on to establish a standard to guide the court's discretion?
Oh, it's not on appeal, right? There's the abuse of discretion to appeal, but you're asking what standard should guide the trial court?
Yes.
So the question is really a question of relevancy, whether the information will be relevant to prove any fact or to make any fact more or less probable. It's a very permissive standard, relevancy.
So you don't have to follow Armstrong, or you don't have to follow any of these state or circuit court decisions that have grappled with this kind of issue on selective enforcement.
So Armstrong is a case about selective prosecution.
I know what it's
And-
about, but if it's not Armstrong, what is it?
So a number of courts, although this court has not, a number of courts have developed a lesser standard that where the
Okay.
information is relevant.
And here's the question.
Yes.
Assuming the lesser standard, did defense counsel in the trial court even come close to meeting that? As I read the motion and as I read the argument on the motion, it essentially says, I'd like to have this. And I don't see any proffer of data made by defense counsel that would come close to meeting the lower standard established in some of these other cases.
So the defense counsel had asked for what's called the NEAR data, NEAR, and the name isn't that important. It sounds like they just wanted to spell NEAR. But the data is incredibly specific. I think everybody in the trial court knew what it meant.
I know what he wanted, but what gave him the right to get it?
So what he wanted was to show that, sorry, what gave him the right to get it
Yeah.
was that it would enable him to show a few things. First, that there were
And
selective,
the cases we've been talking about in the abstract require something more than a desire to look at the data.
right, it would
They
show,
require a good faith basis, I'll phrase it, to think that there is selective enforcement going on here on the basis of race. And our initial showing justifies an order compelling discovery.
well, so the NEAR data is very specific. Some of it is available online, but it's not available online down to the officer. You can see every location where someone is pulled over, what their race is, why they were pulled over. And so just given what's available online, I think that is enough to show that that it's a potential problem. And the question, is it actually improper? And without the data itself, I don't think that the council could show it. That's what he needs the data for.
The cases talk about benchmark data. The ultimate goal of an equal protection argument for selective enforcement is to show that, let's say, white people were committing tinted window offenses at a certain rate, but they were never stopped, and only Black people were stopped for tinted window violations. But in order to begin to establish that sort of proof, you have to have a benchmark for what kinds of people are committing this same violation.
I think that's right, but it's a comparison. And I'll just note that
Compared
this,
to what?
so
What would the data have shown about people who were not stopped?
So I think the way the
For
defense
tinted
counsel would have had
windows.
that was he would have needed an expert. But that expert would not have been appointed unless he had the statistical data from MPD to compare it to, because it's an appointed case. He could, I don't think, and I think he makes this point in the record. He can only get an expert appointed once he has the data, to take the data from MPD and to compare it to the benchmark. And I think he said he would have been able to get that, but he needed the.
Well, that's exactly my point. I don't see any evidence that defense counsel had a benchmark or that the potential expert had any data that would establish a benchmark. So without the benchmark, we're getting nowhere with this discovery.
I think then he's in a catch-22, because if he can't get the data from MPD, then the trial court won't appoint an expert. And if he can't appoint an expert, he can't get the data from MPD.
The point I'm trying to make is I'm not sure MPD has the data.
They do,
Because
there's no question.
wouldn't the benchmark have to establish that white people were committing significant numbers of tinted window violations, but they were not being stopped? What records would there be about people who were never stopped?
So the courts take a number of, the other courts take a number of approaches to this. Some compare just populations. But the point is that that's not in the record, and it's not in the record because there's no way for appointed defense counsel to get that information unless he can get the MPD data. So he'll never get an no defense counsel, appointed defense counsel is going to be able to get benchmark data unless he can get the data that MPD definitely has. They admit they have it. It's not a question in the record. And if you can't get the data from MPD, he can't, and MPD has been hiding this data for years. And only recently did they actually put out any of it, even though the council required them to take it.
In some of the cases, defense counsel set people out, probably standing on overpasses, and made observations about traffic offenses committed by people of different races. And that was one thing that helped establish a benchmark. But I don't see that your client made any effort to gather that sort of data.
So the courts have taken a dim view of just counting. They really do want expert statistical analysis. And there's just no way to get, I mean, appointed counsel can't find an expert to do statistical analysis on his own. He has to get the expert appointed, and the court won't appoint an expert unless he already has data to compare it to. I want to add one more thing about the prior issue about consent. Earlier, Judge Fisher, you said to me, I would like to propose to you an alternative record. And I said, okay. I was not giving consent. I was in that boat when I walked in here. I was acknowledging that you were going to ask me that question, and I was steeling myself for a very difficult question. I think that's what happened to Mr. Ward Minor. Thank you.
Good morning, Your Honor. David Goodham of the United States. May it please the court. Taking the issues in the same order presented by my opponent. First, with respect to the question of whether or not consent is even on the table. As we pointed out in our opening brief, he didn't challenge it in his own opening brief. Further, he didn't challenge it below, and I think that's a very telling feature of this question of whether or not this court can even consider the issue of whether there was indeed consent. And I would direct the court's attention in particular to pages A169 to 173, and even more specifically, Appendix 173. And I think this is the crux of the matter. That's the defendant's argument about consent. And you see the court at that page say, so the next argument, then the next is whether there was consent or not, right? And the defense counsel says, right. And the court says, well, we can't see Mr. Ward Minor's head. Apparently there was some kind of nod. That's what the testimony was. And then the court says to defense counsel, was there something else? Did he say something? And Mr. McDonald says, I think he maybe said like, yeah. And this is the critical point. The next sentence, the defense counsel's argument is, the point I'm making, Your Honor, is once he's in handcuffs, once he's told, put your hands up, don't move, stop, get out. Once he does that, his consent is no longer voluntary, his consent. So again, from the government's perspective, consent, the first part of the analysis here isn't on the table. And what?
Counsel,
I'm sorry.
oh, go ahead.
Go ahead.
Well, the problem for me is that doctrinally, we understand that there's two separate inquiries here. Consent has to precede voluntariness. If a court has already, I guess the problem is, if we think, and I'm not saying we do, but if we think based on our view of the evidence and the body worn camera footage and all of that, that there actually was no consent, then how do we even reach voluntariness? It doesn't make sense.
Sure. No, I understand the conundrum that suggests. My point with this is, again, I do believe we're in a waiver context here, but I think it's telling that apparently everyone below was of the belief that there was a question, there was an answer via the nod, and then
Well, I don't understand that either. Because if the court thought that that the issue of consent was waived, then the court would have said, well, there's no issue about whether there was consent. It's just about whether consent was voluntary. And that's not what the court says, right? The court at 203 goes through and says, right, is there consent? And it talks about Chapman saying, I'm going to pat you down. I'm going to check you. Is that okay?
Sure.
Which is not what Mr. Officer Chapman says.
Sure. No,
So clearly wrong. And the court says it twice, puts those words in the officer's mouth. And so the court finds that there is consent and finds that it's voluntary. And so I don't see how there's waiver if the court actually addresses both parts of the
No,
question.
I understand your Honor's position. Again, my point was buttressing our core argument that there was in fact consent, is that apparently defense counsel was of the opinion that there was in fact consent and that the body worn camera demonstrated that consent. But for sure, the court made a finding on consent, for sure. At A203, the court says, when Officer Chapman says, I'm going to check you, is that okay? The response appears to be an affirmative response. And there's the indicating in the transcript. And as we've articulated in our brief, we think that was a nod. That was consistent with Officer Chapman's testimony. There was a nod, I think.
The problem is that the nod comes before what Officer Chapman says that even could be construed as a request for consent.
Yeah, I heard you articulate, I heard Your Honor articulate that during my opponent's argument. I've watched the body worn camera footage several times. I don't see it proceeding. Certainly, again, defense counsel didn't make such an argument. That is, Your Honor, there can't even be consent because he nodded before the question was even asked.
I mean, which question are we talking about? If the question is that cool, to the extent we consider that a question, my view, and I know we don't have the camera, I mean, the footage that we can display here so I realize this is a little unfair for you, but my view, and I'm not speaking for either of my other colleagues right now, is that the nod, to the extent there was a nod, as indicated by the movement of the hair, almost certainly came before that cool. So if that's the question that you're relying on as asking for consent, or are you relying on the word okay?
No, I think to the extent that there was a question, that's cool. I think that was the basis for the court's determination. And from our perspective, that's not clearly erroneous. The body worn camera footage from my perspective suggests that there was a nod, that it came after the question. I would add that the nod is consistent with the defendant's positioning himself for the frisk and his statement to the effect of, I know I got to spread them. I
want to drill down a little bit on that. I mean, do we want to infer consent or voluntariness from cooperative behavior from suspects who are pulled over by police officers when the alternative is non-cooperative behavior that leads to further difficulties for police officers as well as potentially life-altering incidents? I mean, so we in other words, there has to be a space between cooperative behavior from a suspect and consent.
Sure.
Right? And so why is this not in that space?
I don't think it's in that space because of the sequence of events. That is, again, from the government's perspective, there was a question asked, there was an answer provided via the nod. The defendant also says something.
If we're talking about the sequence of events, don't we need to take a step back? I mean, we're looking at the totality of the circumstances, right? So
Yeah.
the sequence of events starts with the stop, with them putting their hands on the dashboard as directed to do, I believe, by the other officer. Then, being asked to step out of the car. He doesn't want to step out of the car. He's told he has to. He's too slow in the officer's estimation getting out of the car. He's grabbed by the wrists. He's handcuffed. He's removed from the car. He's sort of manipulated. And then there's a conversation where the officer is patting him down on the torso as he's talking to him, trying to get him to admit that he has something on him. I mean, he pats him here, he pats him there. And then has the exchange that we're focusing on, but we can't ignore that whole lead up, right? And
course
that
not.
puts this encounter, I think, in a different light and definitely distinguishes this encounter from the cases that the government has cited about, oh, well, just because they're in handcuffs doesn't mean that they can't consent. I didn't see anything like that sort of lead up where the officer is really in total physical control of the defendant before the question is asked, and not just because he's in handcuffs.
A couple things, Your Honor. Of course, we agree. This is a totality of circumstances analysis. You look at the whole picture. The trial court looked at the whole picture. The trial court considered the body-worn camera footage. The trial
Well, the
court
trial court
considered.
didn't make findings about all of these things. And
The
so
court-
we don't have to ignore them, right? I mean, we are bound by the court's findings such as they are, right? And to the extent we disagree with the findings, we are subject to a clearly erroneous standard. But if the court just doesn't talk about certain things, we're allowed to take note of them, no?
I guess I would disagree to the extent that we have a core factual finding as defined by Schneckloth. That is, consent was voluntary. The Supreme Court has said that is a factual finding. It is a product of a weighing of a number of factors relating to the nature of the encounter and also the characteristics of the defendant.
Right. And so if the court omits some of those factors, disregards, doesn't see, doesn't acknowledge into that weighing, right, we can take account of those. And
Sure. I mean, I think if you're
and there, I guess that my other question is there's a legal aspect to this, right? Because voluntary consent has to be proved by a preponderance of the evidence. So while I understand that we've said a number of times consent is a factual question, I mean, I think probably what we meant was, whether or not the person said yes or no, that's a factual question. But proof by preponderance, I mean, that's a legal question, right?
Again, I take my direction from Schneckloth. I read Schneckloth to stand for the proposition that, yes, there are a number of factors that go into the analysis and lists a series of factors adopted from its confession case law. And at the end of that weighing process, if the court engages in that, then you have a finding of voluntariness. And here, what we have is the trial court took the break after hearing the testimony, after watching the body-worn camera footage, asked for the body-worn camera footage, comes out, said, I've looked at Bastanueva, which is this court's authority on consent, actually lists all the factors in Bastanueva relating to both the nature of the encounter and the defendant's characteristics, and said, I've looked at all those, and I think ultimately I'm finding that this consent was voluntary. That's a factual finding.
Mr. Goodhand, let me drag you back to a question that I understand you don't think has been preserved, but the question of whether there was in fact a manifestation of consent. What the officer said to the defendant is in two parts. The first was he was informing him what I'm about to do. I'm just going to check you, make sure you got nothing on you. Okay. And then there was the statement, that's cool, with a question mark. So question. As I watch the body-worn camera footage, the nodding of the head comes at the point where the officer is informing Ward Minor what he's about to do to him. It's an acknowledgement. I understand what you're going to do to me, but it comes before any question that seeks consent. Let's assume that's a better, not reading, but watching of the body-worn camera footage. How does that fit in with the clearly erroneous standard? I understand that we've written that we're not fact finders, even if we have body worn camera. But can we really ignore what seems to be pretty clear? That any nodding came before the question that arguably sought consent.
I think, if we're at a point of ambiguity, then of course you don't have clear error. And I think from my own perspective that there's ambiguity in the body worn camera footage. If this court, as I read this court's cases, if this court disagrees that there's no ambiguity based on the body worn camera footage, and I know that this court in Hawkins did sort of the same type of analysis and concluded that the basis for the trial court's finding of consent, that is the pushing of the chest, wasn't there on the body worn camera footage. I know this court in that context said we have clear error.
Let me follow up. In this case, though, there is other evidence of consent, which came from the testimony of the officer. And so the trial court has the advantage over us in terms of assessing that. Were there any findings by the trial court about the sequence of the nod in relation to the question?
I think the best finding I have on that is at page A203, which is when officer says, "I'm going to check to you, is that okay?" End of quote. Then we have in the transcript indicating in parens was the response. To my mind, that suggests a sequence. And again, circling back around to one of my core points, that sequence would have been consistent with apparently defense counsel's own take on the body worn camera footage below, because again, I don't think you can read the arguments presented by defense counsel and find anywhere the defense counsel questions the sequence of events or that there was in fact consent. And I think that's telling. And I think that informs, I would say, the breadth and the volume and the extensiveness of the findings of the trial court on that point. The court goes into much more detail and findings on the voluntariness.
Judge Easterly, I see a lot of zeros on the clock there. Would you mind if I ask some questions about the discovery issue?
Not at all.
You heard my colloquy with Mr. Goldberg. You haven't really given us a whole lot of help in figuring out what sort of a standard should govern the discovery issue if we think it's properly before us. So what do we do? Let's assume that the denial of the motion to compel discovery is properly before us. Let's assume that something less than Armstrong governs the trial court's exercise of discretion. What do we do here?
First, my apologies for apparently not giving you enough help in this regard. That I would suggest is a function of the clarity of the waiver that I think we're talking about here. That's why I would suggest God invented Rule 11. But on your Honor's question, I think this is a question that's been wrestled with in the cases in these reverse stash house sting operations. That is, when you're talking about enforcement and there isn't going to be a body of persons who have or have not been subject to a given enforcement policy, then how do you measure? And I think that's what the courts in the cases I cited in the footnote at the end of our brief wrestle with is, should we do a more relaxed Armstrong standard in the special context of cases like that?
And is your footnote meant to say that unless this is a reverse sting stash house case, Armstrong governs and nothing else?
That's certainly it's the import of my footnote is that we can't say the trial court abused its discretion when at best we have a disagreement among the circuits about the governing standard of law, and the standard that informs the defendant's perspective is the more lenient standard, is cabined to just a particular brand of cases. It's not our brand of cases. I certainly agree that I see my zeros here. I would ask that the court affirm the trial court below. And thank you.
Thank you, counsel. Mr. Goldberg, we'll give you just a few minutes.
Thank you. I want to make a couple of points in rebuttal. First, I don't think the government's right to say that the defendant didn't contest consent because he said, I think maybe that this was said or that was said. I think as the government says he's waiving this issue, I think maybe it gives you a waiver, and we're in clear error land anyway. On the question of that's cool. I don't know that even that's cool is a question. I mean, there's no question marks in video. Maybe it's a question. But I think that by that time it didn't really matter. And I have two quick points. The rights of people who are in front of police get chipped away. Originally, the Supreme Court said that a driver can be pulled out of a car. What's the difference between being in the driver's seat and standing outside? And then in Wilson, of course, it's a passenger. And of course, everybody outside can be handcuffed because they can't get behind police. And that made a lot of sense. And all of a sudden you have a passenger who had nothing to do with the car, except he was sitting in it. He had nothing to do with the window tint. And he's being accused and pushed around and handcuffed and pressured because the GRU decided that they would pull over someone for window tint. And I get that they can do that. Pretextual stops are okay. But the GRU does not pick its questions out of thin air. They know how to ask. And the pressure that was put on Mr. Ward Minor was intentional. I will add one more point about the stash house. We didn't even mention this, but the government's cases about the stash house it's true that these are cases about stash houses. But most of them, I think all except one, don't say, hey, this is just a stash house case. Right? They make serious points about what the standard ought to be. And they don't say only for stash houses. So I think that it is true. The government can say, well, these are all stash house cases, and they are. But I don't think that the rules that govern equal protection evidence from those cases has anything to do with the fact that they're stash houses, except that that's where it's the most egregious.
So counsel, I mean, going back to the consent piece, I mean, it seems odd to me that everyone has been relying on this video and the movement of hair, and no one really, I mean, I can't say no one watched the video 20 times like I did, and my colleagues presumably did, but it doesn't seem like it because no one has really talked about the exact timing of the movement of this hair with vis-a-vis the question, that cool. And I don't know, maybe this isn't a question, but I'm just curious as to why that has not really been fleshed out more, either in the trial court or in this court.
So in the trial court, I think the entire trial court's findings are based on the video, virtually not the entire, but almost the entire. It says at various points, I've watched the video. This is all in the video. I have also watched the video second by second and made a second by second transcript of what's in it. I think you're right, but I think it's just not consent. That, you know, when somebody says to you, I'm going to do this, police officer says to you, I'm going to do this. Judge Fisher says, I'm going to give you an alternate version of the record. And I say, okay, it's not consent. It's an acknowledgement that this is about to happen. I think you're right about this, about the sequence. But it just, you know, it was just an acknowledgement. Yeah, you're going to get searched. I mean, you watch the video, he's getting searched. Any other questions? Thank you.
Thank you, counsel. We appreciate your arguments today. The case will be submitted and we stand adjourned. Thanks.
All right. This court is now adjourned.